I agree. Most of the students find labor law very boring. But we had such an amazing teacher who taught us labor law in a wonderful manner and in a way that anybody could remember it a lifetime. And if I'm able to present even 5% of what he has taught, then I'll be more than happy. Hello everybody, I'm Gitanjali Kamath and today we are discussing definition of industry under Industrial Disputes Act. We start with the introduction, then the definition as it is in Industrial Disputes Act, then the amended definition which was given to us in Bangalore Water Supply versus Rajappa case, in which we have triple test and the dominant nature test, then the exceptions to industry. Then we will discuss whether or not charitable trusts are industries, then whether hospitals are industries or not is discussed under State of Bombay versus Mazdoor Sabha and Safdarjung Hospital case. Then whether legal firm is industry, and then municipal corporation is industry or not. In that we have Banerjee versus Mukherjee case, Nagpur Corporation case, and with that we conclude. Start with the definition. Section 2J of the Industrial Disputes Act 1947 defines industry as a business, trade, undertaking, manufacture or calling of employers and includes any calling, service, employment, handicraft or industrial occupation or avocation of workmen. If I read out the definition like this, you will not understand a word, but it's much easier to remember. See, industry means it exists only when there is a relationship between employers and employees. I repeat, industry exists only when there is a relationship between employers and employees. Employers engaged in business, trade, undertaking, manufacturing or calling of employees, and employees engaged in calling, service, employment, handicraft, industrial occupation and avocation. And this is the definition as it is under section 2. In Bangalore Water Supply and Sewage Board versus R. Rajappa, this is a very famous case. The court held that any activity will be industry if it fulfills the triple test as under. These three conditions it has given. The first one, the activity should be systematic and organized activity. Second, with the cooperation between employers and employees. Third, for the production and distribution of goods and services, whether or not capital has been invested for this activity. So this is the triple test which is given under Bangalore Water Supply versus Rajappa case. It is immaterial whether or not there is profit motive or whether or not there is capital. If the organization is trade or business, it does not cease to be one because of the philanthropy animating the triple test and cannot be exempted from the scope of definition of industry. Then the dominant nature test. This test is applied when there are more than one activities. If there is a complex of activities, some of which belong to the definition of industry, some do not fall under the definition of industry, then dominant nature test should be applied. What it says, where a complex of activities, some of which qualify for exemptions and others do not, involves employees in the total undertaking, some of whom are not workmen, or some departments are not productive of goods and services if isolated, even then the predominant nature of the services and integrated nature of the departments would be a true test. What they say, predominant nature and integrated nature. All departments integrated with the industry will also be industry. What they're trying to say is, when there is a complex of activities, as I said, look at the predominant nature, what exactly it is trying to do, and the integrated nature. overall what it is trying to do. If that is an industry, then even the non-industrial parts also fall under industrial definition. Exceptions to industry. Casual activities do not fall under industries. Small clubs, cooperatives, research labs, gurukuls which have essentially non-employee character, single-door lawyer taking help from clerk, selfless charitable activities carried through volunteers like free legal aid, medical service, all these are not industry. Sovereign functions including maintenance of law and order, legislative functions and judicial functions, clinics and dispensaries, all these are not industry. Is charitable institution an industry? Okay, charitable institutions fall under three categories. We'll see which of them are industries and which are not. Charitable institutions fall into three categories. One, those that yield profit, but the profit are not used for charitable purpose. Second, those that make no profit but hire the service of employees as in any other business, but the goods and services which are the output are made available at low or no cost to the poor. Third, those that are oriented on a humane mission fulfilled by men who work, not because they are paid wages, but because they share the passion for the cause and derive job satisfaction. Here the first two categories are industries, but the third on the assumption that they all involve cooperation between the employer and the employee. What they're saying is first two categories, they make profit, they don't make profit, whatever it is, if they are employing people on a regular basis, they fall under industry. But if people are working out of passion for job satisfaction and not as an employee, then such charitable trusts do not fall under the definition of industry. Hospitals. Hospitals are industries or not? In state of Bombay versus Hospital Mazdoor Sabha, Supreme Court held, when the state runs a group of hospitals for the purpose of medical relief to the citizens and for helping to impart medical education, then it is carrying an undertaking within section 2J. Any activity systematically or habitually undertaken for the production or distribution of goods or for rendering material services to the community at large or a part of such community with the help of employees is an undertaking. So firstly, it has decided such an organization is an undertaking. Now, it is the character of the activity in question which attracts the provision of section 2J. Who conducts the activity and whether it is conducted for profit or not do not make a material difference. Thus, activities that have no commercial implications, such as hospitals carried on philanthropic motives, would be covered by the expression undertaking. The mere fact that the government runs such activity is immaterial. In case an activity is industry, if carried on by private person, it would be so if carried on by the government as well. Next, we have management of Safdarjung Hospital versus Kuldeep Singh. In this, it was held that a place of treatment of patients run as a department of the government was not an industry because it was part of functions of the government. Charitable hospitals run by government or private associations cannot be included in the definition of industry because they have not embarked upon economic activities analogous to trade or business. If hospitals, nursing home or dispensary is run as business in a commercial way, there may be elements of industry. Is legal firm an industry? This was answered in National Union of Commercial Employees versus M.R. Meher. It was held that Solicitor's firm is not an industry, although specifically considered, it is organized as an industrial concern. A person following a liberal profession does not carry on his profession in an intangible sense with active cooperation of his employees, and the principal capital which he brings to his profession is his special, peculiar, intellectual and educational equipment. What does this mean? This means that when a lawyer is having an office, there is some profit, but that profit does not come because of the work of the employees. What work he is doing there solely depends upon his intelligence, his capacity, and the employees are only an add-on helping him carry out the less important works. So legal firm is not an industry. Next, municipal corporation. Municipal corporation was discussed in Banerjee versus Mukherjee case. The Supreme Court observed that in ordinary or non-technical sense, industry or business means an undertaking for capital and low labor cooperate with each other for the purpose of producing wealth in shape of tools, goods, etc. for making profit. A public utility service such as railways, telephone, supply of power, light or water to public may be carried on by private companies or business corporations. And if such public utility service are carried on by municipal corporation, it does not cease to be industry. Just because they are carried on by corporation, it does not cease to be industry. Therefore, municipal corporation can be industry. Next, in Nagpur Corporation versus its employees, it was held. A corporation is an industry, but industry cannot include what are called regal or sovereign functions of the state. Neither the investment of capital nor the existence of profit-making motive is necessary element of the modern concept of industry. If a department of municipality discharges many functions, some pertaining to industry as defined in the Act, the other not industrial activities, the predominant function of the department shall be the criterion for the purpose of this Act. With this, we end the discussion on definition of industries. Please subscribe to the channel and let me know in the comment box what subjects you would like me to cover. Thank you.